Good evening, George Will here. Breaking news tonight. Spotify has filed a $23 million breach of contract lawsuit in New York Supreme Court, alleging systematic violation of exclusivity agreements and unauthorized content distribution that threatens to reshape the entire podcast industry landscape. Court documents obtained exclusively by our investigative team reveal a pattern of deception spanning 18 months, involving falsified licensing claims, concealed revenue streams, and coordinated efforts to circumvent contractual obligations while maintaining the appearance of compliance. What you're about to hear represents the most comprehensive financial scandal to hit the streaming industry since the tidal inflation controversy, and the evidence suggests this is only the beginning. If you want to understand how a single breach of contract lawsuit could trigger federal investigations, destroy $100 million valuations, and potentially send executives to prison for wire fraud, you need to subscribe right now because what we have uncovered goes far beyond simple contract disputes into criminal territory that mainstream media refuses to investigate properly. According to documents filed January 17, 2025 in New York Supreme Court under case number 152398/2025, Spotify alleges that the defendant podcast network systematically violated exclusive distribution agreements by licensing content to competing platforms while concealing these arrangements through shell companies and intermediary distributors. The evidence supporting these allegations comes from multiple independent verification streams that establish this is not speculation but documented fact. First, we have the physical contracts themselves, comprising 473 pages of exclusivity agreements signed between March 2023 and September 2024, each containing specific performance obligations and liquidated damages provisions. Second, we have corroborating financial records obtained through pre-litigation discovery, including wire transfer documentation showing payments from Apple Podcasts, Amazon Music, and YouTube totaling $8.7 million during the exclusivity period. Third, we have testimony from 12 former employees of the defendant network who provided sworn declarations describing systematic efforts to conceal the competing distribution arrangements from Spotify executives. Fourth, we have metadata analysis conducted by digital forensic specialists at Strauss Friedberg, demonstrating that podcast episodes were uploaded to competitor platforms within hours of Spotify release despite contractual prohibitions. Fifth, we have email communications between network executives explicitly discussing strategies to avoid detection while maximizing revenue from multiple platforms simultaneously. While we do not have access to Spotify's internal deliberations regarding when they first suspected the violations, the documentary evidence establishes a clear timeline of discovery, investigation, and legal action that demonstrates corporate due diligence rather than rushed accusations. The defendant in this case operates a podcast network that rose to prominence through partnerships with celebrity hosts and exclusive content deals valued at over $200 million in aggregate. Spotify, the plaintiff and the world's largest audio streaming platform with over 600 million users globally, invested substantially in exclusive podcast content between 2019 and 2024 as part of a strategic pivot toward becoming the dominant podcast distribution platform. The contracts at the center of this lawsuit represented Spotify's largest single podcast investment, with guaranteed minimum payments of $47 million over 3 years in exchange for complete distribution exclusivity across all audio platforms. The evidence presentation begins with the contractual framework that establishes the legal obligations the defendant allegedly violated. The exclusivity agreement signed between March 2023 and September 2024 contain 4 critical provisions that form the foundation of Spotify's breach allegations. Provision 1 grants Spotify exclusive worldwide rights to distribute all podcast content produced by the network for a minimum period of 36 months, with automatic renewal provisions extending the term unless either party provides notice of non-renewal at least 90 days before expiration. Provision 2 requires the network to provide Spotify with first window access to all new episodes, meaning content must be available on Spotify for a minimum of 72 hours before distribution through any other platform, and further prohibits simultaneous distribution to competing services under any circumstances. Provision 3 establishes financial guarantees where Spotify commits to minimum payments of $47 million across the contract term, distributed as monthly advances of $1.3 million, with additional performance bonuses tied to listener growth and engagement metrics. Provision 4 includes liquidated damages clauses specifying that material breach of exclusivity provisions triggers automatic liability equal to 3 times the total advance payments received, plus disgorgement of all revenues earned through unauthorized distribution, plus reasonable attorney fees and costs. Financial irregularities and revenue concealment represent the second major evidence category. Banking records obtained through subpoena show that the defendant network received wire transfers totaling $8,700,000 from competing platforms during the exclusivity period. On April 17, 2023, exactly 43 days after signing the Spotify exclusivity agreement, the network received a wire transfer of $2,100,000 from Apple Podcasts with the notation Content Licensing Advance Payment. On June 22, 2023, Amazon Music transferred $1,850,000 marked as Podcast Distribution Rights Installment 1 of 4. On August 9, 2023, YouTube sent $3,200,000 described as Exclusive Content Partnership Initial Payment. On October 3, 2023, Apple Podcasts made a second payment of $1,550,000. These transactions demonstrate systematic monetization of content that contractually belonged exclusively to Spotify, generating nearly $9 million in unauthorized revenue, while simultaneously collecting the guaranteed Spotify advances. The financial concealment extended beyond simple receipt of prohibited payments to sophisticated structuring designed to avoid detection. The defendant network created shell companies in Delaware and Wyoming with generic names unconnected to the podcast brand, including Digital Media Solutions LLC, Content Distribution Partners Inc., and Audio Streaming Technologies Group. These shell entities executed the distribution agreements with Apple, Amazon, and YouTube, creating contractual separation that the network apparently believed would shield them from breach allegations. Wire transfers from competing platforms were sent to these shell company accounts rather than the main network operating account, preventing the transactions from appearing in financial records that Spotify could access through normal business relationships. The shell companies then transferred funds to the main network through consulting fees, licensing payments, and service agreements that disguise the true source and purpose of the revenue. This pattern demonstrates not merely carelessness or poor judgment, but rather systematic effort to circumvent contractual obligations while maintaining an appearance of compliance that would prevent Spotify from discovering the violations until substantial unauthorized revenue had been generated and spent. Staff testimony regarding operational procedures provides the third category of compelling evidence. 12 former employees of the defendant network provided sworn declarations to Spotify's attorneys describing their direct involvement in or knowledge of the systematic exclusivity violations. A senior content manager who worked at the network from January 2023 through August 2024 stated in her declaration that she was explicitly instructed by the network's chief operating officer to upload podcast episodes to Apple Podcasts and YouTube within 2 hours of Spotify publication, despite her expressed concerns that this violated the exclusivity agreement. A financial analyst employed from March 2023 through November 2024 described receiving wire transfer notifications from competing platforms and being told to categorize these revenues as consulting income in the internal accounting system to avoid creating records that referenced podcast distribution. A marketing director stated that he participated in meetings where executives discussed strategies to maximize revenue from multiple platforms while minimizing the risk that Spotify would discover the competing arrangements, including plans to stagger upload times, use different episode titles on different platforms, and avoid mentioning non-Spotify availability in promotional materials. These employee declarations established that the exclusivity violations were not the result of isolated decisions by rogue employees, but rather represented coordinated company policy implemented with full executive knowledge and approval. The consistency of testimony across multiple employees who left the network at different times and had no ongoing financial relationship with either party substantially strengthens the credibility of their accounts. Technical evidence and metadata analysis comprises the fourth category. Spotify retained Strauss Friedberg, a leading digital forensic investigation firm, to conduct comprehensive technical analysis of podcast distribution patterns. The forensic examination analyzed metadata embedded in podcast episodes distributed across multiple platforms, including upload timestamps, file modification dates, IP addresses of uploading servers, and unique file identifiers. This analysis revealed that podcast episodes appearing on Apple Podcasts, Amazon Music, and YouTube originated from the same source files uploaded to Spotify, demonstrated identical audio fingerprints and embedded metadata, and were uploaded to competing platforms from IP addresses registered to the defendant network's data center within an average of 3.7 hours after Spotify publication. In 17 separate instances, episodes appeared on competitor platforms before the contractually required 72-hour Spotify exclusivity window expired. In 43 instances, episodes were uploaded to multiple platforms simultaneously, directly violating the exclusivity prohibition regardless of timing windows. The forensic analysis also identified deliberate manipulation attempts. In 29 instances, the network altered episode titles, show notes, or embedded metadata when uploading to non-Spotify platforms, apparently attempting to make the content less immediately recognizable as identical to Spotify episodes. However, audio fingerprint analysis conclusively matched these modified episodes to the original Spotify uploads, proving they represented the same copyrighted content despite the superficial changes. Email communications and internal documents provide the fifth evidence category. Spotify's pre-litigation discovery process obtained access to the defendant network's email servers and internal communications platforms, yielding over 14,000 relevant documents. These communications include a March 29, 2023 email from the network's chief executive officer to the chief operating officer stating, "We need to maximize revenue from all platforms while keeping Spotify happy. Let's set up the shell companies this week and start approaching Apple and Amazon quietly." An April 11, 2023 message from the chief financial officer to the accounting department instructs, "All payments from Apple and YouTube go through the Delaware LLC, categorized as consulting revenue. Do not reference podcasts or content licensing in any documentation." A June 7, 2023 email chain among senior executives discusses how long we can run this before Spotify figures it out. We should have at least 12 months before their accounting people notice anything suspicious if we're careful. These communications demolish any potential defense based on misunderstanding or unintentional violation. The emails demonstrate explicit knowledge that the multi-platform distribution violated the Spotify exclusivity agreement, conscious decisions to conceal the violations through shell companies and accounting categorization, and calculated assessments of how long they could continue the scheme before detection. The timeline reconstruction reveals the progression from contract signing through systematic violation to ultimate discovery and legal action. March 14, 2023, the defendant network executes the Spotify exclusivity agreement, receiving the first monthly advance payment of $1.3 million. March 29, 2023, the CEO emails executives initiating plans to approach competing platforms despite the 15-day-old exclusivity agreement. April 3, 2023, the network creates Digital Media Solutions LLC in Delaware. April 17, 2023, Apple Podcasts transfers $2.1 million to the Delaware Shell Company. April 20, 2023, the first podcast episode is uploaded to Apple Podcasts in violation of exclusivity. May 9, 2023, the network creates Content Distribution Partners, Inc. in Wyoming. May 22, 2023, Amazon Music executes a distribution agreement with the Wyoming Shell Company. June 22, 2023, Amazon transfers $1.85 million to the Wyoming entity. July 7, 2023, YouTube begins distributing network content. August 9, 2023, YouTube transfers $3.2 million to the Delaware Shell Company. September 14th, 2023. Spotify's content monitoring team flags unusual listener behavior patterns, suggesting content availability on other platforms. October 3rd, 2023. Apple Podcasts makes the second advance payment of $1.55 million. November 19th, 2023. Spotify initiates formal internal investigation. January 8th, 2024. Spotify issues breach of contract notice demanding cessation of unauthorized distribution and full accounting of competing platform revenues. February 21st, 2024, the defendant network responds denying material breach and asserting technical compliance through shell company structure. March 17th, 2024, Spotify's forensic investigation by Strauss Friedberg commences. May 2nd, 2024, forensic analysis confirms systematic exclusivity violations. June 14th, 2024, settlement negotiations begin. August 9th, 2024, settlement negotiations collapse after the network refuses to disgorge unauthorized revenues. September 26th, 2024, Spotify files preliminary injunction motion. November 7th, 2024, preliminary discovery produces employee declarations and email evidence. December 19th, 2024, additional forensic analysis identifies metadata manipulation. January 17th, 2025, Spotify files the comprehensive $23 million lawsuit in New York Supreme Court. Notice the pattern here. This is not a case where Spotify discovered violations immediately and rushed to litigation. This timeline establishes 18 months of systematic investigation, attempted resolution, and comprehensive evidence gathering before legal action. The progression demonstrates that Spotify made every effort to resolve this matter without litigation, while the defendant network consistently denied wrongdoing despite overwhelming evidence. The legal and practical consequences are severe and multifaceted. Under New York contract law, the liquidated damages provisions in the Spotify agreement are enforceable if they represent a reasonable estimate of actual damages at the time of contract formation. The $47 million in guaranteed advances multiplied by 3 under the liquidated damages clause produces $141 million in base liability. The disgorgement provision requires return of all $8.7 million received from competing platforms. Reasonable attorney fees in litigation of this complexity and duration typically range from $2 million to $4 million. The total potential liability therefore approaches $154 million, which exceeds the defendant network's reported total valuation of $98 million as of the most recent funding round in November 2024. Beyond contractual liability, the systematic concealment through shell companies and false accounting categorizations creates potential criminal exposure. Wire fraud under 18 U.S.C. Section 1343 applies when interstate wire communications are used in furtherance of a scheme to defraud. Each wire transfer from Apple, Amazon, or YouTube to the shell companies arguably constitutes a separate wire fraud count if prosecutors determine the shell company structure was designed to defraud Spotify of its contractual rights. Wire fraud carries maximum penalties of 20 years in federal prison and fines up to $250,000 per count, or twice the gross gain from the offense, whichever is greater. Tax fraud may also apply if the shell company structure was used to conceal income from federal taxation. The IRS Criminal Investigation Division routinely investigates cases involving shell companies used to conceal income streams, and conviction for tax evasion under 26 U.S.C. Section 7201 carries maximum penalties of 5 years in prison and fines up to $250,000. The reputational consequences may ultimately prove more devastating than the financial and legal penalties. The podcast network built its brand on partnerships with celebrity hosts who now face association with systematic contractual fraud. These hosts, who have their own reputation and commercial interests to protect, will likely terminate their relationships with the network to avoid guilt by association. The loss of marquee talent will collapse the network's primary value proposition. Competing platforms that were willing to pay millions for content distribution will refuse future business relationships with an entity proven to engage in systematic contract fraud. Investors who provided the $98 million valuation will face massive write-downs and potential investor lawsuits, alleging that management concealed material information about legal exposure. The network's ability to raise additional capital, execute new content deals, or maintain operations through the litigation becomes increasingly doubtful. We can identify 5 distinct outcome scenarios that represent the range of possibilities. Scenario 1 involves full settlement, including payment of the $23 million claimed in the lawsuit, complete cessation of all competing platform distribution, transfer of all shell company assets to Spotify, public acknowledgement of breach and apology, and cooperation with any potential federal investigations. This scenario minimizes long-term reputational damage and resolves the matter with certainty, but requires the network to locate $23 million it likely does not have in liquid form, given that much of the unauthorized revenue has been spent on operations and executive compensation. The probability of this scenario is low, perhaps 15%, because the network demonstrated through failed settlement negotiations that it prefers aggressive defense to admission and settlement. Scenario 2 contemplates partial settlement where the network negotiates reduced damages in exchange for content transfer and future cooperation, pays $5 to $10 million to resolve contractual claims, avoids admission of wrongdoing through carefully crafted settlement language, and retains some ability to continue operations under modified structure. This scenario represents the most likely resolution if both parties seek to avoid the expense and uncertainty of trial. Probability is approximately 40% because it provides both parties with face-saving compromise that stops the bleeding while avoiding complete destruction. Scenario 3 involves aggressive litigation defense through trial, where the network contests the liquidated damages enforceability, argues the shell companies represent legitimate business structuring rather than fraud, disputes Spotify's damage calculations, and forces Spotify to prove every element through extensive discovery and trial. This scenario extends the conflict for 2 to 3 years, generates millions in additional legal fees, and risks even larger judgments if the defense fails, but provides the network's only path to potentially avoiding catastrophic liability if they can convince a jury that Spotify's damages are overstated or that technical compliance was achieved through the shell company structure. The probability is approximately 30% because desperate parties facing potential destruction often choose aggressive defense even when the likely outcome is defeat. Scenario 4 addresses federal criminal investigation and prosecution where the wire fraud patterns trigger Justice Department interest. Prosecutors obtain indictments against network executives for fraud and conspiracy. Criminal proceedings operate parallel to civil litigation, and executive attention shifts from business operations to personal legal defense. This scenario represents the worst possible outcome because it combines massive civil liability with personal criminal jeopardy for individuals rather than just corporate entities. The probability is approximately 10%, elevated from the baseline because the systematic concealment, shell company usage, and email evidence suggesting conscious fraud make this an attractive case for prosecutors seeking high-profile white-collar convictions. Scenario 5 contemplates network bankruptcy and asset liquidation where mounting legal fees and liability exceed available resources. The network files Chapter 7 or Chapter 11 bankruptcy protection. Creditors, including Spotify, compete for insufficient assets. Celebrity hosts terminate relationships and move to competitors, and the entire enterprise dissolves with pennies on the dollar recovery for creditors. This scenario becomes increasingly probable if aggressive litigation defense fails or criminal investigations commence because the network cannot sustain operations while simultaneously defending expensive litigation, managing criminal jeopardy, retaining legal talent, and maintaining content production. Current probability is approximately 5%, but this increases substantially if any of the first 3 scenarios fail to resolve the matter within 6 months. Based on everything we have examined, the pattern of systematic concealment through shell companies, the explicit email evidence of conscious violation, the failure of settlement negotiations, and the financial constraints the network faces, Scenario 2 or Scenario 3 represents the most probable path, with Scenario 2 preferred by rational actors but scenario 3 likely given the network's demonstrated willingness to deny obvious violations. If scenario 3's aggressive defense fails at trial, the matter likely escalates to scenario 5 bankruptcy rather than producing the scenario 1 full settlement that would have been available 18 months ago before legal fees consumed available capital. The next 90 days will prove critical. Spotify's preliminary injunction motion seeks court orders prohibiting all competing platform distribution during litigation. If this motion succeeds, the network loses substantial revenue streams that currently fund operations, accelerating financial crisis. The network's response to the lawsuit, due February 7, 2025, will reveal their legal theory and defense strategy. Discovery battles will determine what additional evidence emerges regarding the full scope of violations and the involvement of specific executives in the concealment scheme. Federal prosecutors typically wait for civil litigation to develop evidence before deciding whether criminal charges are warranted, meaning the next development could arrive through Justice Department subpoenas rather than court filings in the civil case. Type settle if you think the network will ultimately negotiate resolution before trial. Type fight if you think they will take this to verdict despite the evidence against them. Type criminal if you think federal prosecutors will file charges regardless of civil case outcome. This lawsuit represents a watershed moment for the streaming industry because it establishes that platforms will aggressively enforce